Welcome back, sir. Let us start with the next chapter in the previous exam question papers. Free consent. Which consent, sir? Free consent. So, what is free consent? Let us see the questions from the free consent chapter. The first question, May 2018. This question was asked for the 5 marks, sir. So, first, define fraud, whether silence will amount to fraud as per Indian Contract Act. If you define fraud, he will give you 2 marks. Beta, here 2 questions are there, beta. If you don't write definition, no, he will not give you marks. Definition of the fraud, he will give you 2 marks. Whether silence will amount to fraud or not, if you explain this thing, no, beta, he will give you 3 marks. 3 plus 2 totally 5 marks. But the definition is different, meaning is different. He is not asking the meaning of the fraud, he is asking the definition of the fraud, beta. So definition of the fraud is defined under section 17. Fraud means and includes any of the following activities committed by a party to contract or with his connivance. Connivance means helping someone to do wrongful activity. Helping someone to do wrongful activity. So, any activity committed by party to contract, that means I am doing the wrongful activity, or with his connivance I am helping someone to do wrongful activity, or by his agent, my agent is doing wrongful activity. Who may do the wrongful activity? SG or SG help or SG agent. So by a party to contract or with his connivance or by his agent with an intention to deceive. The main intention of the wrongful activity is to deceive, మోసం చేయాలని, धोखा देने के लिए बाजू वाले को, है ना, to deceive another party, Rohit or his agent, Rohit's agent, or induce him to enter into. Induce means influence. Induce means influence. I'm influencing Rohit to enter into contract. Hey, Rohit, come on, आओ, है ना बेटा? So it will be done by party to contract or with his connivance or with his agent. I am doing the fraud or I am helping someone to do fraud. I am like, but the fraud is done by my agent. On whom? Rohit or Rohit's agent, or I am influencing Rohit to enter into contract. That is the meaning of the fraud. है ना बेटा? Again, some explanation is there under that. Let us see what that explanation also, beta. And a suggestion of as to fact which is not true. Suggestion as to fact which is not true. The fact is it is an ordinary pen, but I am suggesting it as a Gandhiji pen. The fact is it is an ordinary pen, but I am suggesting it as a Gandhiji pen. Suggestion as to fact which is not true. The truth is not a Gandhiji pen, but I am telling it is a Gandhiji pen. By one who does not believe it to be true. I am not believing it as a Gandhiji pen, but I am telling it as a Gandhiji pen. What I am doing here? Fraud. I told Rohit, so take this pen for 1000 rupees. It is an ordinary 10 rupees pen, but I said to Rohit, it is a Gandhiji pen, rare pen, take it for the 1000 rupees. I am not believing it as a Gandhiji pen, but I am telling it as a Gandhiji pen to deceive the Rohit. It is a fraud. And active concealment of a fact by one having knowledge thereof. So active concealment, John Bush ke kavalani, I am hiding a defect. Concealment means hiding. Active intentional hiding of the fact to deceive other party by having knowledge thereof. So there is a crack on the chair. I'm purchasing a imported chair. I'm purchasing the imported chair. Otherwise, I'm selling an imported chair, but there was a crack on the chair. Rohit will not purchase that chair if you see the crack. I'm applying the paint on the crack so that he cannot identify that crack on the chair. It's an active concealment. Hiding the crack on the chair is an active concealment. Why I'm hiding, beta? To deceive the Rohit. Any promise made without any intention to perform. Rohit is there. Rohit said to Sweetie, I love you, I'll marry you. Cutie, I love you, I'll marry you. Puppy, I love you, I'll marry you. Sweetie, I love you, I'll marry you. Munni, I love you, I'll marry you. The same dialogue he said to 10 girls. but he don't want to marry anyone है ना बेटा. So he's making a promise. I promise you I'll marry you. I promise you I'll marry you. I'll promise you I'll marry you. He told the same dialogue to 10 girls, but he don't want to marry anyone. So what he's doing beta? Fraud. Any promise made without any intention to perform it, and any other activity fitted to deceive or some other activities beta, the main intention of the activity is to deceive the other party, that amounts to fraud. Or any such omission, activity or omission law specifically declares to be fraudulent act is there. For example beta, as per the NI Act, as per the Banking Regulation Act, if you're issuing a check without having a balance, available balance in your account is 10 rupees. Available balance in your account is 10 rupees. You're issuing a check for 1000 rupees. It's a fraud because you know that it will bounce. You know that it will not honor. It's a fraud as per the Banking Regulation Act. So when act is that, the act is saying that this it amounts to fraud. समझ में बेटा? Clear ना? So if you read this whole definition बेटा, you will get the how many marks बेटा? 2 marks if you remember all these things. है ना बेटा? So fraud means the false representation of the fact to deceive the other party. He will give you half mark. He may not give half mark also beta. Meaning is different, definition is different beta. If you read all the above things, he will give you 2 marks. So fraud means false representation of the fact to deceive the other party. If you read like that, he will not give you marks, but you may come to your home, you will give 2 out of 2. Anna beta, don't make correction of your own answer sheet beta. జనాలు ఏం చేస్తారు, ఏదో రాస్తే రెండుకి వచ్చేసి వాడు మార్క్స్ వేసుకుంటాడు. ఇక నెక్స్ట్ head, one more question is beta, whether silence will amount to fraud? Answer is no sir. Mere silence amount to fraud? Answer is no. Silence does not amount to fraud. Being a seller, I need not disclose all the defects in my articles. For example, there are 2 pens are there. This pen is 20 rupees, this pen is only 5 rupees. Why beta? Because there is a defect in this pen. This pen is 20, this pen is only 5 rupees. Why? Because there is a defect in this pen. After working for 5 days, it will not work. After running for 5 days, it will not work. Being a seller, whether I will inform the buyer, don't take it because after 3 days it will not work. I will not say generally. So being a seller, I need not disclose the defects in the goods, and moreover, it is a duty of the buyer to choose the goods which will satisfy his requirements. So Benz car is there, 4 people only. Alto also 4 people only beta. So how many people can sit in the Benz car? 4 people. How many people can sit in the Alto car? 4 people. How many wheels are there for Benz? 4 wheels. Alto 4 only. But why Alto is only 5 lakhs, but why Benz is 1 crore rupees? Because the quality. So Alto, Maruti Alto, they will not tell that this car is not having the efficient car, this engine is very less engine. Will they tell beta? They will not tell. In the same way, being a seller, we need not disclose the defects in the goods. It's a duty of the buyer to choose the good which will satisfy your requirement. So the statement is incorrect. That means silence will not amount to fraud. As per Indian Contract Act 1872, a party to contract is under no obligation to disclose the whole truth to other party. I need not disclose the whole truth. Being a seller, we will not disclose the whole truth to the buyer. So silence does not amount to fraud. And there is a concept of caveat emptor. Caveat emptor means let the buyer be beware. Let the buyer be aware. Emptor means buyer. Caveat means careful, cautious, careful. Emptor means buyer. Hey buyer, while choosing the goods, while buying the goods, be careful, because I don't know your purpose na. So you should be careful while choosing the goods which will satisfy your requirements. Caveat emptor, that is, let the purchaser be beware of the rule applicable to contract. So purchaser should be careful while choosing the goods. Seller may not disclose the defects in the goods. But being a seller, why I will disclose the defects in my goods beta? I will not. So there is no duty to speak in such cases. Silence does not amount to fraud. Similarly, there is no duty to disclose the facts which are within the knowledge of both parties, both buyer and seller. Clear na? So buyer know this, seller know this, I need to disclose it again. So what is the moral of the story beta? whether silence will amount to fraud. Answer is no. Silence does not amount to fraud. समझ में बेटा? Let us go to next second question, sir. Let us see the second question from the fraud chapter, sir. Same question. Mere silence is not fraud, but there are some circumstances where silence is fraud. Explain the circumstances as per the provisions of the Indian Contract Act. 7 marks, sir. 7 marks. Here, if you explain this one, he will give you 3 marks. If you explain this one, he will give you 4 marks. He is asking the exceptions also. First, general rule, whether silence amount to fraud, sir. Silence does not amount to fraud. Some exceptions are there, beta. In those exceptional cases, silence will amount to fraud. Beta. So he is asking the exceptions also. That's why he is giving the 7 marks. Beta. This question was asked in the year 2019. First, whether silence amount to fraud? No. Mere silence as to facts likely to affect the willingness of a person to enter into contract is not a fraud. Is not a fraud. So mere silence does not amount to fraud unless the circumstances of the case are such that regard being to the, it is duty of the person keeping the silence amount to fraud unless silence. So what he is saying, madam, unless the circumstances of the case are such that regard being had to them, it is the duty of the person keeping the silence to speak unless his silence it itself is equivalent to speech. You need not this thing also, but it is exception, beta. But he is saying in this lines, beta, in some cases silence will amount to fraud anta. We will read this exception in the exceptional case, beta. In some exceptional cases, silence will amount to fraud. We'll see what are that. Beta. General rule, silence will not amount to fraud. Beta. So it is a rule of law that mere silence does not amount to fraud. Mere silence does not amount to fraud. A contracting party is not duty bound to disclose the whole truth to the other party or give him the whole information in his position affecting the subject matter of the contract. That means the party to contract need not disclose the whole the facts. Silence will not amount to fraud. But exceptions are there, beta. What are them? This rule is contained in explanation to section 17 of the Indian Contract Act, which clearly states the position that mere silence as to facts likely to affect the willingness of a person to enter into contract is not a fraud. But exceptions. In the following exceptional cases, silence will amount to fraud. The first one is duty of a person to speak anta. Duty of the person to speak. In some exceptional cases, it is a duty of the seller to disclose the defect in the good. If it does not disclose, no, that will amount to fraud. What are that? First one, where the parties to contract stands in the fiduciary relationship. Fiduciary means utmost good faith. Utmost good faith. అచ్చా భరోసా, మంచి నమ్మకం, నమ్మకం మీద ఆధారపడి ఉన్న సంబంధాలు. भरोसा के ऊपर रहता ना रिलेशंस, उसको बोलते हैं utmost good faith. Like father daughter, father son. If I am, for example, I am having a horse, beta. Which horse, beta? Horse. What is this, beta? Horse. Goda. Assumption. है ना बेटा? It's a insane horse. Which horse, beta? Insane horse. It's a pagal horse. Rohit is asking me, Srinath sir, how much is the horse? I said 1 lakh rupees. He gave me 1 lakh rupees. I gave the horse. Whether I made a fraud on the Rohit? No. Because I need not disclose that the horse is an insane horse. For example, Rohit is my son. He was asking me, Daddy, how much is the horse? I said 1 lakh rupees. He gave me 1 lakh rupees. I am giving the horse. I made a fraud on my son. Because when my son is purchasing a horse, he believe me that my father will not give me defective good. है ना बेटा? So here the person in whom confidence is reposed is under a duty to act with utmost good faith and make full disclosure of the middle facts concerning the agreement known to him. Here silence will amount to fraud. Example, father and son. So if I do not disclose the defect, it will amount to fraud because we stands in the fiduciary relationship. And contract of insurance also, but when you taking the insurance policy, health insurance, it is a duty to discuss all your problems, health problems to insurance company. Otherwise, it is voidable the option of the insurance company because it is a duty of the that policy holder to inform the all his problems to insurance company before taking the policy. You know? So otherwise, that is a fraud. In a contract of marine insurance, fire insurance, life insurance, there is a implied condition that full disclosure of material facts shall be made. Full disclosure should be made. Otherwise, insurer is entitled to avoid the contract. But that amounts to fraud only because insurance company you have to disclose everything better. And contract of marriage. Contract of marriage also based on the utmost good faith only better. So before marrying someone, you have to inform to your would be how many girlfriends you are having, how many boyfriends you are having, how many affairs you are having, how many health issues you are having, because marriage is based on the faith. So నమ్మకం దెబ్బతింటా లేకపోతే ఎస్ నో సార్ భరోసా జాతా. దట్స్ వై సో every marital fact must be every material fact must be disclosed by the parties to the contract of marriage, and contract of family settlements. But I am not explaining all the things here. My focus is only on the questions. We have discussed all this thing in the regular class already. Contract of family settlements. So these contracts also require full disclosure of the material facts within the knowledge of the parties, because family settlement is based on the faith and allotment of the shares. When the company is issuing a shares to investors, company has to disclose everything in the prospectus beta. So person issuing a prospectus at the time of public issue of the shares and debentures by a joint stock company have to disclose all the material facts within their knowledge in the prospectus. In where beta? In the prospectus. Look sir everyone. Otherwise it becomes audible. Second one, where silence is equivalent to speech itself. Here also we have to disclose beta. Where silence is equivalent to speech. Actually, I am having a horse. Which horse? Insane horse. Which gurram? A pagal horse beta. Rohit is asking, Srinath sir, how much is the horse? I said 1 lakh. He gave me 1 lakh rupees. I gave the horse. Whether I made a fraud? Yes or no? No. Second example is answer. Rohit was asking, Srinath sir, if you remain silent, I will assume that horse is sane horse. What Rohit said to me? Srinath sir, if you remain silent, I will assume that horse is a sane horse. Then I have to inform him, Rohit, don't assume like that. It is not a sane, it is a insane. If I don't tell him, no beta, my silence will amount to fraud. Because here my silence is equivalent to speech that the horse is a sane horse. Samajh mein beta? So where silence itself is equivalent to speech, here silence will amount to fraud. Because what he said about Rohit, Srinath sir, if you remain silent, I will assume it is a sane horse. Then I have to inform Rohit, don't assume like that, it is a insane. For example, A says to B, if it does not deny it, that means if you remain silent, I shall assume that the horse is sound. A says nothing. Here his silence will amount to speech that horse is sane and sound. So his silence will amount to fraud here. So this question was asked twice already. Whether silence will amount to fraud, and exceptions also 18 and 19. And next question, but third question. Discuss the essentials of undue influence under Indian Contract Act. Undue influence essentials is asking, sir. So let us try to understand what are the essentials of a undue influence. So what is the undue influence? Which influence beta? Undue influence. Let us try to understand, sir. Discuss the essentials of undue influence as per Indian Contract Act. This question was asked in same question was asked in 2011 and 2019. So in 2011 CA foundation was there, sir. So and CA interval in CA IPC also undue this Contract Act was there. So what are the essentials of a undue influence beta? He may give for 4 marks, 4 to 5 marks. Question was asked for 5 marks. First essential. The essentials of undue influence as per Indian Contract Act are as follows. First one, relationship between two parties. There must be some relationship between the two parties, like father, son, Guruji, disciple, doctor, patient, master, servant, income tax officer, and assessee, like that. A person can be influenced by other when near relationship exists between two parties. I am going on the main road. Can someone influence me just like that? No, sir. So who can influence me? My father, maybe duly or unduly. My teacher, my doctor, my lawyer, my master. So there must be some relationship between the parties. And position to dominate the will. Out of these two parties, one must be dominating party, other must be weaker party. Police officer dominating, constable weaker, master dominating, and employee servant weaker. Guruji, spiritual advisor dominating disciple is the weaker party. Doctor dominating patient weaker. Teacher student, like that. So the relation between the parties exists in such a manner that one of them in a position to one of them is in a position to dominate the will of the other, and the person is deemed to be in such a position in the following cases. He's giving the examples also, but in which cases there is undue influence. Three types again, four types, where the party stands in the real and apparent authority. Apparent means appearance, beta. Just by seeing you can identify that someone is dominating. For example, if you go to hospital, compounder and the doctor is dominating, compounder is weaker. Just by seeing his dressing style you can understand. Or politician and politician follower, కార్యకర్త అండ్ రాజకీయ నాయకుడు అయినా బెట. సో పొలిటీషియన్ విల్ బి హెవీ బాడీ, హెవీ జ్యువెలరీ, వైట్ అండ్ వైట్ ప్యాంట్ అండ్ షర్ట్, లైక్ దట్. హెవీ బాడీ విల్ బి దేర్, బట్ డామినేటింగ్ బాడీ this position will be there. And the followers of that party, weaker parties generally. Just by seeing his language, body language, I can say that this guy is dominant, this guy is weaker. That is apparent authority. Apparent means by appearance, just by seeing, where the person holds a real authority over the other, as in case of master and servant, doctor and patient examples. And fiduciary relationship based on the utmost good faith, like Guruji and disciple, where the relationship of trust and confidence exists between the parties in a contract, such that such type of relationship exists between the father and son, solicitor and client, husband and wife, debtor and creditors. These are some of the examples of the fiduciary relationships, beta. Next, mental distress, doctor and patient example. An undue influence can be used against a person to get his consent on a contract where mental capacity of a person is temporarily or permanently affected by the reason of mental or bodily distress, illness, or the old age. So when you're not feeling well, you'll go to doctor. The doctor may confer advantage of your fear. Doctor may say that something is there in your stomach, you may die tomorrow if you don't do surgery. So like that they may take unfair advantage also. Next one is the unconsiderable bargains. Unconsiderable bargains means not reasonable bargains. Not reasonable bargain. For example, you went to vegetable market. One tomato vendor is there. Tomato is a perishable good. Tomato is a perishable item. Because if you preserve the tomato for 2-3 days, no, it will perish. A small farmer came from a village to sell tomatoes on the Hyderabad. For example, already 8 baj gaya, it's 8 o'clock in the night. So tomato per kg 40 rupees. You're asking, will you give for 10 rupees or not? Even he don't like, he will give it, because otherwise he has to bring back the tomatoes to his village. More of that will perish. They will perish. That is not reasonable. Kg tomato 40, you're asking for how much? 5 rupees, 6 rupees, 2 rupees. That is not reasonable bargain. So you're taking unfair advantage of his innocence being a farmer. So where one of the parties to contract is in a position to dominate the will of the other, and the contract is apparently unreasonable, that is unfair, it is presumed by the law that consent must have been obtained by undue influence. Unconsiderable, that unreasonable bargains are witnessed mostly in the money lending transactions. Which transaction? Money lending also. Because Rohit is there, his father is not good, his wife is not good, they're hospitalized, he was in need of the money. I said, I'll give the money if you give me 5% interest, 6% interest. It's fraud, no beta. Frankly speaking, I'm taking unfair advantage of his position. Otherwise his father will not survive, his mother will not survive, his daughter will not survive if you don't operate. So what this hospital people will do, beta, or money lenders will give, I said I will give you money if you give me 6% interest, 10% interest also. So next, the objective must be to take the unfair advantage. Which advantage beta? Unfair advantage. The main purpose of the undue influence is to take the unfair advantage of the weaker party, where the person is in a position to influence the will of the other in getting consent, and must have the objective to take the advantage over the other. Advantage kaadu, it is the unfair advantage. Which advantage beta? Unfair advantage over the weaker party. And burden of proof. But who has to prove that burden of proof lies on whom beta? Dominating or weaker? Dominating party has to prove that there is no undue influence. So the burden of proving the absence of the use of dominant position to obtain unfair advantage will lie on the party who is in a position to dominate the will of the other. Simply, so dominating party has to prove that there is no undue influence. समझ में बेटा? So this question was asked twice in the exam. Essentials of the undue influence. Next question is the coercion beta. 2019 5 marks. Explain the term coercion and what are the effects of coercion under Indian Contract Act. Two questions are there. What is coercion? He will give you 2 marks. Effects of coercion, he will give you 3 marks. So what is the coercion beta? Coercion means committing an act forbidden by IPC, threatening to commit an act forbidden by IPC, unlawful detaining of the property, threatening to detain the property unlawfully. If you read these 4 points, you will get the 2 marks. Definition beta. So coercion means committing or threatening to commit an act forbidden by Indian Penal Code, or unlawful detaining, threatening to detain the property unlawfully to the prejudice of the person. To the prejudice means opposite beta. Prejudice means opposite. Look about everyone. Opposite of any person, whatever, with the intention of causing any person to enter into contract agreement. So I am influencing him to enter into agreement. Otherwise, I will do some activity. Which activity? I'll commit an act forbidden by IPC. I'll commit an act threatening to commit an act forbidden by IPC. I'll do any of the activity if don't enter into agreement with me. So that is a coercion. Coercion means committing an act forbidden by IPC, or threatening to commit an act forbidden by IPC, unlawful detaining of the property, threatening to detain the property unlawfully. If any of these 4 things are there, no beta, because of these 4 things he is entering into agreement. That is a coercion. Next, effects of the coercion beta. Contract induced by coercion is voidable at the option of the party whose consent was obtained. That is, it becomes voidable at the option of the aggrieved party. Which party beta? Aggrieved party. As to the consequence of the rescission of the voidable contract, the party rescinding a void contract should, if he has received any benefit thereunder from the other party to contract, restore such benefit so far as may be applicable to the person from whom it is received. That means, if the aggrieved party is making it as a rescinding, if aggrieved party is making it as a void contract, the party getting benefit must restore the benefits they have received. For example, beta, I kept the gun against the Rohit. I am taking his bike for 1000 rupees. Beta, keeping a gun against other person is a punishable offense under Indian Penal Code. I kept the gun against the Rohit and I am taking the bike for only 1000 rupees. It's a coercion. So everything was recorded in the CC camera. Rohit went to court of law. He proved everything. I must return the bike to Rohit. Rohit must return the 1000 rupees to me. Yes sir, no sir. Next, a person to whom money has been paid or anything is delivered under the coercion must be returned it. That means both the parties has to restore it. There are 2 effects of the coercion. First one is the voidable. Second one is the both the parties has to restore the benefits they have received. Let us go to next question, sir. 6th question. So next question. Silence does not amount to fraud. The same question was repeated 5th time beta. 3rd time. So generally silence does not amount to fraud. But some exceptions are there beta. On those exceptional cases, silence will amount to fraud. Beta. So first question, second question, 6th question also same beta. Next 7th question. 7th question is important beta. P sells by auction to Q a horse which P knows to be unsound. I am selling a horse beta. So P means Parshuram selling the horse to Kurushi, for example. So P selling the horse to whom beta? Kurushi Q. P knows that he's an insane horse. है ना बेटा? The horse appears to be sound, but P knows about unsoundness of the horse. Is this contract is valid in the following circumstances? P says nothing about the unsoundness of the horse to Q. Whether contract is valid, whether fraud is there. Valid contract. Silence does not amount to fraud, so it is not a fraud. It is not a fraud. Second question. P says nothing about it to Q, who is P's daughter, who has just came of age. Now here Q is the daughter of the P. Whether it amounts to fraud better now? Yes or no? It amounts to fraud because P and Q stands in the fiduciary relationship. Third one. If Q says to P, if you do not deny it, that means if you remain silent. If you remain silent, I shall assume that horse is sound. P says nothing. Whether it amounts to fraud, sir? Yes, it amounts to fraud. Already, I gave example. Rohit said to me, Srinath sir, if you don't tell anything, if you remain silent, if you do not deny, I'll assume that it is a sane horse. Then I have to inform, hey Rohit, don't assume like that. Because if I remain silent, no, that will amount to fraud better. Already Rohit said to me, Srinath sir, మీరు ఏమి చెప్పకపోతే హార్ట్స్ మంచిదే అనుకుంటాను అన్నాడు. అప్పుడు నేను చెప్పాలి, అలా అనుకోక రోహిత్, అది పిచ్చుగురం అని చెప్పాలి. Otherwise it amounts to fraud. So how to answer this question beta? Step number 1, step number 2, step number 3. Step number 1, provision of the law. As per section 17 of the Indian Contract Act, mere silence as to facts likely to affect the willingness of a person to enter into contract is not a fraud. Unless means exceptions beta. Unless the circumstances of the case are such that regard being given to them, it is the duty of the person keeping silence to speak, and unless his silence is itself equivalent to speech. These two are exception beta. This is the first exception, that is the fiduciary relationship. This is the second exception beta. Silence equivalent to speech. In these two cases, silence will amount to fraud. Facts of the case. P sells by auction to Q a horse which P knows to be unsound. The horse appears to be sound, but P knows about the unsoundness of the horse, but is not telling anything to Q. Decision. 3 cases. First one, it is a valid contract. The contract is not valid. The contract is not valid. We have discussed already above also beta. See, it is a valid contract. It is a fraud. It is a fraud. है ना बेटा? First case, valid contract. Since as per section 17, mere silence as to facts likely to affect the willingness of a person to enter into contract is not a fraud. Here, it is not the duty of the seller to disclose the defects, so it does not amount to fraud. Second case, the contract is not valid. It is a fraud. Since as per section 17, it becomes P's duty to tell to Q about the unsoundness of the horse because Q and P are the father and daughter. Fiduciary relationship exists between P and his daughter Q. Here, P's silence is equivalent to speech and amounts to fraud. Third case also, as per section 17, P's silence is equivalent to speech and it amounts to fraud. This how you have to answer beta. You will not lose even 1 mark also beta if you write like this. This much of clarity is there now. Full marks you will get. Next question beta. Explain the concept of misrepresentation. You should read everything about the misrepresentation beta. He may give you for the 4 marks max, and beta 4 to 5 marks. 4 marks. First, he is giving the definition of the misrepresentation beta. Lengthy definition beta. Misrepresentation. As per section 18 of the Indian Contract Act, misrepresentation means and includes a this definition beta you should read as it is. A positive assertion in a manner not warranted by the information of the person making it of that which is not true, though he believe it to be true. क्या बात कर रहा है? A positive assertion. That means a positive information. Positive information. In a manner not warranted by the information of the person making it. That means it is a negative information but telling it as a positive information. Why I am telling that it is a positive information? Because I am believing it as a positive information. I sold this pen. It's an ordinary pen. I sold this pen to Rohit by saying it is a Gandhiji pen. What I made on the Rohit beta? Fraud. SG known that it is a ordinary pen, but selling it to Rohit by saying that it is a Gandhiji pen. Rohit is innocent here. So I'm telling it as a Gandhiji pen. I sold it this pen to Rohit for 10 lakhs rupees or 1 lakh rupees or 10 lakhs rupees. Rohit is believing it as a Gandhiji pen. Rohit sold the same pen to Mahesh. Rohit sold the same pen to Mahesh. Mahesh also believing it as a Gandhiji pen. Rohit also believing it as a Gandhiji pen. Rohit made the misrepresentation. Here fraud is there. Here see a positive assertion, that means positive information, in a manner not warranted by the information of the person making it. That means Rohit should not say that it is a Gandhiji pen, but he said it is a Gandhiji pen. Why? He believed it to be true. Rohit believed that it is a Gandhiji pen. That's why he said like that. Any breach of duty. Breach means थोड़ा गलत हो गया, तप्पु చేశాడు. क्या हो गया बेटा? गलत हो गया. क्या गलत हो गया? Let us see. Any breach of duty. Any breach of duty without any intention to dissuade. गलत तो हो गया, but intention is not to dissuade other party. किसी को धोखा देने के लिए नहीं, है ना बेटा? సో ఎవరినో మోసం చేద్దామని కాదు, తప్పు చేశాను కానీ మోసం చేద్దామని కాదు. ఎనీ బ్రీచ్ ఆఫ్ డ్యూటీ వితౌట్ ఎనీ ఇంటెంట్ టు డిసీవ్, వితౌట్ ఇంటెంట్ టు గెయిన్ ఎన్ అడ్వాంటేజ్ టు ద పర్సన్ కమిటింగ్ ఇట్, ఆర్ anyone claiming under by him, or by misleading another person, prejudice means opposite to the prejudice of any other person claiming under him. I am giving a wrong statement with Rohit, but my intention is not to deceive Rohit, not to deceive Rohit's agent. गलत तो हो गया, but my intention is not to deceive sir. Causing however innocently a party to an agreement to make a mistake. I am doing the mistake, but my mistake is an innocent mistake. As to the substance and the substance of the thing, majority of the thing, which is subject matter of the agreement, I am making the mistake on the subject matter of the agreement, by my intention is not to deceive other party. That amounts to fraud beta. Next question is important beta. This question is important beta. Question was asked 2003-2019 after 16 years. Copy paste question beta. Believe me sir, if you do these questions beta, the same questions will appear in the exam also if luck is good, hai na beta. Let us start the next question beta. 9th question. Yeah, so next question important sir. 9th question, same question will repeated so many times in the exam. If you observe the question also beta, see Sohan condition defect 40, copy pasted sir question, copy pasted without changing comma full stuff. So Sohan important. Sohan induced Suraj to buy his motorcycle saying that it was in a very good condition. So Sohan said to Suraj beta. Who said beta? Sohan said to whom beta? Suraj. सूरज भाई देखो एक गाड़ी अच्छा है बोल के बेच दिया, है ना बेटा. तो Sohan induced Suraj to buy his motorcycle saying that it was very good condition. After taking the motorcycle, Suraj complained that there was many defects in the motorcycle. Then Suraj said, my dear Sohan, there was so many problems in the car, है ना बेटा. So biker car, so there are so many problems are there in the motorcycle. Sohan proposed to get it repaired and promised to pay 40% of the cost of repairs. Sohan said, let us go for repair, and if 100 rupees is incurred for repair, no, I will bear 40%. Do one thing, you bear 60%. है ना बेटा. Suraj agree for that also beta. Sohan has to pay 40% of the repair. Buyer Suraj has to pay the 60%. After few days, the motorcycle did not work at all. After some days, the motorcycle is not working. Now Suraj want to resign the contract with Sohan. Can he resign? Answer is no sir. Why? Because when Sohan said to give 40%, Suraj said okay, that is final acceptance. That is final acceptance of the particular motorcycle. Subsequently, he cannot resign. Here, Sohan thought that bike is good or car is good. It's a misrepresentation. It is a misrepresentation. The intention of the Sohan seller is not to deceive Suraj sir. He was thinking that bike is good condition. He's giving the bike to Suraj. Subsequently, he came to know that there are some defects are there. It is a misrepresentation. Since misrepresentation is there, the seller said, okay, chalo, I will bear 40%, you bear the 60%. For that, buyer also agreed. That is the final acceptance of the contract. Subsequently, he cannot. So let us see the answer also. Important question, sir. Provision of the law. Aggrieved party in case of misrepresentation by the other party can rescind the contract generally. Yes or no, sir? Here buyer can rescind, but buyer said, give me 40%, I will not rescind. That is the final acceptance. The aggrieved party loses the right to rescind the contract if he, after becoming aware of the misrepresentation, takes the benefit under the contract in some way, affirms it. Here buyer is accepting it. Buyer is accepting it. Subsequently, he cannot rescind it. Facts of the case. Sohan induced Suraj to buy his motorcycle, saying that it is a good condition. After taking the cycle, Suraj complained that there was many defects in the cycle. Sohan proposed to get it repaired and promised to pay how much? 40% of the cost of repairs. After few days, cycle is not at all working. Now, buyer want to rescind the contract. Decision. Accordingly, in the given case, Suraj could not rescind the contract as his acceptance to the offer of Sohan to bear 40% of cost of repairs impliedly amounts to final acceptance of the particular bike. Subsequently, he cannot rescind the contract again. Beta? Clear na? Next question, beta. Next question. Let us see the next question, beta. Question number 11. Yeah. So let us see the next question, sir. A student was induced by his teacher. Student and teacher. Student is the weaker party, beta. Which party, beta? Weaker party. Induced by the teacher. There is a dominating party. To sell his brand new car to the later at less than the purchase price to secure more marks in the exam. I said to my student Rohit, if you don't give me your car for the 10,000 rupees only, I'll fail you in the exam. Accordingly, the car was sold by student to faculty. However, father of the student pursued him to sue his teacher. State whether student can sue the teacher. Answer is yes, sir, because there is undue influence is there. This question was asked in November 2019. So, provision of the law. Provision of the law. As per section 16 of the Indian Contract Act, a contract is said to be induced by the undue influence where the relations subsisting between the parties are such that one of them in a position to dominate the will of the other, and he uses that position to obtain the unfair advantage over the other. So, and dominating student is a weaker party. So, a person is deemed to be in the position of dominant will of the other, where he holds the real and apparent authority. Real and apparent authority, where party stands in the fiduciary relationship, and where party makes a contract with a person whose mental capacity is temporarily or the permanently affected by reason of the age, illness, etc., etc., etc. A contract is bought as a result of the coercion, under influence, fraud, misrepresentation would be voidable at the option of the party whose condition was caused. So there is giving the effect of the under influence also. Beta. Facts of the present case. A student was induced by his teacher to sell his brand new car to the later means to the teacher at less than the purchase price to secure more marks in the exam. Accordingly, car was sold. However, father want to file a case with the teacher. Can he? Yes. And decision, yes. A can sue his teacher on the ground of undue influence and the provisions of Indian Contract Act. If you write like this, you will get 5 out of 5. It is 4.5. Full marks. Next, explain the circumstances under which the person is deemed to be in a position to dominate the will of the other person under the Indian Contract Act. But he is asking the assumptions as to undue influence. But if you are observing undue influence question 4th time, beta. Previous to twice, above one, the 4th time undue influence, beta. So he's asking the assumptions as to undue influence. Assumptions as to undue influence. 4 assumptions will be there, beta. So position as to dominate the will. A person is deemed to be in the position in the dominant position. In dominate position in the following cases. Such position is dominant position. So where the parties, where real and apparent authority is there, where a person holds a real and apparent authority over the other, as the case of master and servant, doctor and patient, etc. Fiduciary relationship, where relation of trust or confidence exists between the parties to contract. Such type of relationship is exist between the father and son, solicitor and client, husband and wife, debtor and creditor. Fiduciary relationships, beta. Mental distress, best example, the doctor and patient. An undue influence can be used against the person to get his consent on the contract where the mental capacity of the person is permanently or temporarily affected by the reason of the mental or bodily distress, illness or the old age. And unconsiderable bargains, that is unreasonable bargains. Example, while giving money lender to poor people, while taking the vegetables from the farmers, where one of the parties to contract is in a position to dominate the will of the other and the contract is apparently unconsiderable, unreasonable, it's not fair, it's unfair. It is presumed by law that consent must have been obtained by undue influence. Unconsiderable bargains are witnessed mostly in the money lending transactions, etc. Next, same question is asking the meaning of the misrepresentation and Suraj case by the third time. Same case law. Suraj and one more guys was there. Sohan and Suraj. है ना बेटा? 2003. May 19 and 2003. 2019, 2003. Again same question beta. If you are observing, same questions are repeating. 2019, 2003 and 2020 also beta. Explain the concept of misrepresentation in the matter of the contract. Sohan induced Suraj to buy his motorcycle, exactly copy pasted, saying that it is very good condition. After taking the motorcycle, Suraj complained that there are many defects in the motorcycle. Sohan proposed to get it repaired, promised to pay how much beta? 40%. That is the final acceptance. Cost of the repairs. After few days, motorcycle did not work at all. Now Suraj wants to resign the contract. Decide, can he? Answer is no beta. है ना? Same question is repeating beta. Beta, so no, the same questions will come again and again and again. Next question, what do you understand by coercion? Repeated. Under the Indian Contract Act, coercion, same question, repeated. Next, 15th question beta. 2002 question beta. A applies to a banker for a loan at a time when there is a stringency in the money market. That means there is no money in the market, like COVID. In the COVID, so there is no money with anyone. So A applies to banker for the loan at the time when there was a stringency in the money market. A banker declined to make the loan except at unusually high rate of interest. High rate of interest. A accept the loan on those terms. Whether contract is induced by undue influence. Answer is no. Why it is not undue influence? Because there is no money. When supply is less, no demand will be more. Generally, interest rate is, for example, 1%. Because there is no money in the market, the lender was charging 3%. But it is undue influence? No. Because there is a stringency in the money market. The same example is there in our material also. If you observe in our material, the same example will be there in the undue influence. If you're reading my material. So next, here we should write beta. Step number 1, step number 2, step number 3 is homework. है ना? Step number 1, what is undue influence? Step number 2, facts. Step number 3. So it is not a undue influence because there is a stringency in the money market. So examine the validity of the contract when the acceptance from the offer is obtained by coercion or undue influence. Point out the difference between the coercion and undue influence. Question was asked in 2005 and 2011 also beta. Difference between the undue influence and the coercion. So he may give for maximum 5 marks beta. Coercion and undue influence. Coercion, there may or may not be related to each other. Parties to contract related to each other under some sort of relationship. But in case of coercion, parties may be related, may not be related also. I am going on the main road. Suddenly I kept a gun against some stranger on the main road. Can I? Yes, that is a coercion. But to influence and de-influence, there must be relationship. Father, student, father, son, and there must be some relationship between the parties. Consent. Consent is obtained by giving a threat of offense punishable under the Indian Penal Code. Consent is obtained by dominating will here. Here physical pressure is there. Here moral, mental pressure is there. It can be effective even on a stranger. It can be effective only on a party to contact, but not on a stranger. And here restoration is compulsory. Restoration is optional. The aggrieved party has to restore the benefits received. The party awarding the contract may or may not return the benefit. That is, weaker party may return, may not return the benefit. It is the option of the court of law. Presumptions. There is no presumption of undue influence, but there is a presumption of undue influence in case of real and apparent authority and fiduciary relationships, and mental stress or the physical stress and unconscionable transactions. In these four cases, there is a assumption of undue influence. So coercion has to be proved by the party alleging it. In no case it is presumed by the law. So there is no presumption of the undue influence. You have to prove it. But it may be presumed by law under certain circumstances. The party against whom such presumption is lies must disapprove that. That is, dominating party has to prove that there is no undue influence. Nature of liability. The party committing the crime may be punishable under IPC. It does not involve any criminal liability. Burden of proof lies on the aggrieved party. Burden of proof lies on the dominating party. He has to prove that there is no undue influence. Yes sir, no sir. So, next question, 18th question, sir. So, what is the 18th question? Difference between the fraud and misrepresentation. Question was asked in 2016. Fraud. Wrong representation is made willfully with the intention to deceive other party. Wrong representation is made without any intention to deceive other party. The person making the wrong statement does not believe it to be true, but he believes it to be true. Beta. Here is the innocent misrepresentation. He believes the wrong statement as a true statement. Aggrieved party can claim damages. Aggrieved party cannot claim damages here. Next question, 2006 question beta. Exceptions to unilateral contract. Generally, unilateral mistake is not a fraud. Two exceptions are there beta. Identity of the parties and nature of the agreement. In these two cases, even silence will amount to, that is even unilateral mistake is valid beta. Generally, it is not generally unilateral mistake is valid. Mistake is valid contract. Which contract beta? Valid contract. Because only one of the parties under a mistake. That is your fault, not my fault beta. Two exceptions are there beta. First one is identity of the person. Second one is the nature of the contract. In these two cases, it will be void agreement. It will be void agreement. I give two examples also beta. Nature identity of the person. I want to enter into contact with Suresh by entering into agreement with Ramesh. He is a twin brothers, Ramesh and Suresh. I have to enter into contact with whom beta? Suresh. By mistake, I enter into contact with whom beta? Ramesh. That is a void agreement because there is no meeting of the minds. Next, nature of the contract. So, I give an example. Grandmother was signing the agreement thinking that it is a gift deed, mortgage deed, but in fact it is a gift deed beta. She is thinking mortgage, but in fact it is a gift deed. It is the nature of the contract, nature of the agreement, frankly speaking. Beta. So, in these two cases, it is a void ab initio agreement. Last question beta. May 2012. Types of the bilateral mistakes beta. So it is so many types beta. So bilateral mistake, types of the bilateral mistakes. Mistake as to existence of subject matter, mistake as to quantity, mistake of the quality, mistake as to price, mistake as to identity, mistake as to title. These are the various types of the bilateral mistakes. Beta. Bilateral mistakes is two types broadly. Bilateral mistake as to this is not the point beta. This is the first one. This is the second one beta. Bilateral mistake as to facts. Bilateral mistake as to fact. That fact is of how many types beta? 6 types. As to existence, quantity, quality, price, identity and the title. Hina date question only. So with this so many questions are there, but still some extra questions are there. We'll see one by one. Yes sir, no sir? So let us start with the next question, sir. A student was induced by his teacher to sell his brand new car to the later for the less than the purchase price to secure the more marks in the examination. Accordingly, the car was sold. However, the father of the student pursued him to sue the teacher. State on what ground student can sue the teacher? On which ground, beta? Undue influence. Which influence, sir? Undue influence. Question is repeated, beta. I am telling you now, the same questions will come. A believed the engine of the motorcycle was to be in the excellent condition. This one is 21 is undue influence. Next, 22nd question. Listen, sir. A believed that a believed the engine of the motorcycle to be in excellent condition. A without getting it checked on a workshop, told B that the motorcycle was in good and excellent condition. On the statement, B bought the motorcycle whose engine was proved to be defective. State the nature of the statement given by A. It is a fraud or misrepresentation? Misrepresentation. If you are observing, this question is similar to that question only, beta. Suraj and Sohan. Next question, coercion versus undue influence. Next, fraud versus misrepresentation. That also second question, beta, repeated. And A intending to deceive B. That means fraud. Intending to deceive B. B falsely represents that 500 mounts of indigo are to be made annually at A's factory and thereby induces B to buy the factory. What is the validity of the agreement? It is a fraud. It is a fraud because he knows that it cannot produce that much of the quantity, but he said that it can able to produce the 500 mounts of the indigo. So it's a intentional misrepresentation of fact is there. So it is a fraud. Step number 1, define the fraud. Step number 2, explain the fact. Step number 3, so consent is obtained by the fraud. Next question, beta, 26th question. All are ICA questions only, but all these are ICA questions only, practice questions. So A by misrepresentation leads B to believe erroneously that 750 tons of the sugar is produced per annum at a factory of the A. B examines the accounts of the factory which should have disclosed if ordinary diligence had been exercised by the B that only 500 tons have been produced. Thereafter, B purchased the factory. Discuss the validity of the contract. Valid and invalid? Valid and invalid? I'll read once again, beta, question. I will read the question again. A by misrepresentation leads B to believe erroneously that 750 tons of sugar is produced per annum at the factory of the A. So A was misleading. A said to B, my dear B, from this factory we can produce 750 tons of the sugar. B examines the accounts of the factory which should have disclosed if ordinary diligence, common sense. Diligence means common sense. Ordinary diligence means common sense. Ordinary diligence means common sense that had been exercised by B that could produce only 500 tons have been produced. B examined the books of accounts of the factory. He found that in the accounts maximum production can be only 500 tons but not the 750 tons. Thereafter, B purchased the factory. Discuss whether B can rescind the contract. B cannot. Contract is valid. Contract is valid. B cannot rescind the contract. B cannot rescind the contract. B cannot rescind the contract because when B is buying a factory, he knows that the maximum production is only 500 tons because he has examined the books of accounts of the factory also, and he knows that there can be only 500 tons of the 500 tons can be produced. We have seen one example also, beta. Exceptions to fraud, exceptions to misrepresentation. If the part, first exception, if the party to agreement has the means of discovering truth by ordinary diligence, common sense, he cannot rescind based on the fraud or misrepresentation. I give an example also at that time. I am selling the cat as a dog. Cat as a dog. Can he rescind the contract, beta? No. If you have common sense, you can know that it is not a dog, it is a cat. Elephant as a cat. है ना बेटा, he know that it is not an elephant, it is a cat. है ना बेटा, that example I give. I give one more example also. He is selling nano car as a bench car. है ना, so he cannot rescind the contract. है ना, so see every example that I am discussing in the class coming in the exam. If you are observing, है ना बेटा, so he cannot. Next question बेटा. A offers to sell his ambassador car to B, who believes that A has the Fiat car and agrees to buy the car. Decide the validity of the contract. Decide the validity of the contract. A offers to sell his ambassador to B, who believes that A has only Fiat car. Beta, I give this example. Beta, Rohit is having two cars. One is Benz, one is the Audi. So he always use only Benz car. He never use the Audi. So he want to sell the Audi. He want to sell the Audi. Here, whether the I will explain the same example again, beta. This example I will explain. This is the first example I will explain the free content, beta. Rohit is there, beta. Is having two cars. How many cars, beta? Two cars. One is Jaguar, and other one is the Audi. He always uses Jaguar car. He never use the Audi car. So Rohit want to sell which car, beta? Audi. Rohit is asking SG. SG sir, will you purchase my car? Will you purchase my car? I am thinking he's selling the Jaguar car. Hey, beta. I said okay Rohit, I want to purchase the car. Whether my consent is free, whether the consent is good, beta, it's a void ab initio consent. Which consent, beta? Void. In the mind of the offerer, Audi is there. In the mind of the offering, Jaguar is there. There is no meeting of the minds. Hey, beta, this question, this is that question, beta. See, if you're observing, beta, every example I have discussed in the class is appearing in the exam. If you're observing, so A offers sell his ambassador car to B, who believes that A has only Fiat car. In the mind of the seller, ambassador is there. In the mind of the buyer, Fiat is there. There is no meeting of the minds. It's a void ab initio agreement. है ना बेटा? Next question number 28 बेटा. 28 questions we have seen बेटा. I am telling you 100% no question will come from this chapter which is not discussed by us, because all questions we have 30 questions we have discussed better from one chapter. So Mr. Sham owned a motor car. He approached Mr. Vikas and offered to sell his motor car for 3 lakhs. Mr. Sham told Mr. Vikas that the motor car is running at the rate of 30 kilometers per liter. Both fuel meter and speedometer of the car is working properly, perfectly. Mr. Vikas agreed with the proposal of the Sham and took the delivery of the car by paying the 3 lakhs to Mr. Sham. After 10 days, Mr. Vikas came back with the car and stated that the claim made by the Sham regarding the fuel efficiency was not correct. Therefore, there was a case of the misrepresentation. So, buyer saying that there is a misrepresentation is there. Referring to the provisions of the Indian Contract Act, decide whether Vikas can rescind the contract or not. Whether Vikas can rescind the contract or not. But if the buyer had the means of discovering the truth by ordinary diligence, he cannot rescind the contract. He cannot rescind the contract. So, as per section 19 of the Indian Contract Act, when the consent to agreement is caused by coercion or fraud or misrepresentation, agreement is to contract is voidable at the option of the aggrieved party. A party to a contract whose consent was caused by fraud or misrepresentation may, if he think fit, insist that contract shall be performed and that he shall be put in a position in which would have been if misrepresentation was made true. What he is saying, beta, that is restoration, beta. Restoration. The language is like that, beta. If the voidable contract becomes void contract, no, beta, both the parties have restored the benefits they have received. Exception, beta, if a party to agreement had the means of discovering truth by ordinary diligence, we cannot rescind the contract. If such consent was caused by misrepresentation or by silence or fraudulent, with the meaning of section 17, the contract nevertheless is not voidable if the party whose consent was caused by the means of discovering the truth by ordinary diligence, he cannot rescind the contract. He cannot rescind the contract. Facts. In this situation, in the situation given in the question, both fuel meter and speedometer of the car were working perfectly. Vikas had the means of discovering the truth by ordinary diligence. Therefore, the contract is not voidable. Hence, Vikas cannot rescind the contract on the ground of the misrepresentation or the fraud. So, this kind of questions will come in the exam, sir. This question came in the year November 2020 RTPC, sir. RTP. So we have seen the question till the 2020. Clear, beta? So next we will discuss in the next class. Have a great time. Enjoy the day. Prepare well. SG signing off.